we are. Just kidding. What's up? Good morning. Good morning. Good morning. Welcome to Defense Diaries. I am your host, Bob Mata, and I am joined by my beautiful, brilliant. Look at her. Look at that. Bright and early. Doesn't matter what time of the day. Anytime she opens her eyes, like as soon as she opens her eyes, it's gorgeous time. It's gorgeous time. What is up, beautiful?
Hey, babe. Hey, y'all.
Good morning, guys. What's up? A little early morning Delphi. I don't think that we've ever done this before. For Delphi, at least. Like it's typically evenings, and that's typically. So, babe, did you get the memo sent to you via the clerk?
Oh, I didn't look because
Dizzy, I don't know if Dizzy sent it to me via email or not.
let me see. It's probably too early. I probably haven't gotten it this morning.
No, it was yesterday. It came out yesterday.
I know, but I didn't see it from her. Yes. Oh, yeah, I got it. 7 o'clock
Right.
morning.
Forward it over to me. So, because we have little time to waste. I've got to we got to get this read, analyzed, out the door by 10 o'clock. I got to do my recording, my weekly thing with Tony Bruschi, and then we're off to tell us it. I moved it up to 11:20 a.m. Central Time, 12:20 Eastern, obviously 9:20 Pacific Time for Tellus. And so let's see here. Put my D&D on. All right. Just wait for a few minutes. So I haven't even looked at this yet. We had a long streaming day yesterday. And I just didn't get a chance to look at it. So this is going to be a fresh read. So I'm excited. I'm excited to see the law. I always like the law. When they support bald propositions with actual law is nice. Because ultimately, at the end of the day, that's what matters in trials. That's what determines what's going to be admissible, what's going to be inadmissible. So the law is very important. Sometimes legal proceedings have very little to do with common sense. So, all right, I got it up. Thank you, babe. Let's waste not, want not right now. Let's go. It's a long one. I might split up the reading between you and I, frankly. I got a long day of streaming, so we might have to go. We'll see. If I lose steam, I'm going to recruit you to help me read.
7 pages.
Shoo! That's what I'm talking about. Let's see. Is that it? Brief in opposition. Okay. Is this it? Let me see.
Yeah, it's it. It's the one I just sent you.
Yeah, it's weird. It said
because they're opposing the state's motion to eliminate.
Oh, that makes sense. I forgot.
Right. Wait, but so then that's not. Oh, that's what they saved it as, right? Got it.
Right. All right. So let's go, y'all. Let's go. A little early morning law. It's like you just woke up, rolled out of bed, and went to your con law class in your first year of law school. So
yes, Professor Mata.
Yeah, I don't even have my coffee yet, so this could be brutal. All right, memorandum of law in support of admission of evidence of alternative theories of the crime and third-party perps. Comes now Richard Allen by counsel and provides this memo of law in support of admission of evidence of alternative theories of the crime and third-party perps. Now, babe, the way that I want to do this today, as opposed to so feel free. I'm giving you free reign to interrupt me because we're not going to have time to read through the whole thing and then do legal analysis afterwards. So
what I think is we should read the whole thing and then we can come back tomorrow night and do more legal analysis on it. I don't know.
I mean, we could do that.
I say that because I haven't researched the cases that are in here. But
well, I mean, so
I'll chime in if there's something. But
I love the chime-ins. The chime-ins are perfect. All right, good. Okay, so the intro, Mr. Allen has a constitutional right under the wait, I gotta immediately get this to scrolling because the page thing makes me want to I would end up on trial for murder because that's how the page thing like makes me feel when I flips or whatever. All right, so Mr. Allen has a constitutional right under the 6th, 14th Amendments of the United States Constitution and Article 1, Section 13 of the Indiana Constitution to present evidence attacking the credibility of the prosecution's case, undermining the believability of the prosecution's witnesses, identifying third-party suspects, and establishing Mr. Allen's theory of this case or the case. This right is the cornerstone of the adversarial process and essential to a fundamentally fair trial, and denial of this right constitutes structural error. How do you feel about that statement right there?
I don't know what they're talking about.
All right. So, well, they're saying to deny him.
Structural error is a very specific word, so specific legal term. So, I mean, due process claims are not structural error. Denial of your attorney of choice is a structural error, which means if you make this mistake and you deny them their lawyer, doesn't matter how great the other lawyer is. It doesn't matter if they're actually prejudiced by it. It is a per se, that is it, violation. It's going back. So I guess I have to wait till it gets flushed
to get to the meat of the matter, see what kind of law this side out. All right. So whether rooted in directly in the due process clause of the 14th Amendment or in the compulsory process or confrontation clauses of the 6th Amendment. So like if you all watch us, you should know what due process is. Due process under the law is essentially that there is a process and that the defendants are afforded that right, and it includes notice. And in terms of the process itself, you can't just have trials by ambush. The defendant is owed under the Constitution due process under the law, meaning that they are notified of the charges against them. When you talk about confrontation clause, that's literally what it sounds like. It's you have the right to confront those who are accusing you of things, including witnesses, victims, anybody that's accusing you. You have the right to confront them at trial. That's a very brief explanation of what those things mean. So the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Crane v. Kentucky, a 1986 case. This right is accomplished through the right to offer the testimony of witnesses to compel their attendance in trial. And that's an Indiana case they cite there. It is necessary for both the accused and the prosecution to present their version of the facts to the jury so it may decide where the truth lies. It's like what I'm always telling you guys. These are just theories. Theories, kids. They weren't there. Neither one of them know. If you have a rare case, and I'm like, I don't know if it's ever happened where I've never heard of a case where the prosecuting attorney like actually was present during the commission of a crime, because they couldn't prosecute because they'd have to be a witness. So like it can't have, like, these are it's theories. So just as an accused has the right to confront the prosecution's witnesses for the purposes of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of the due process of law, Washington v. Texas. When the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross-examination, which is what they did in Reed, or his own witnesses and exhibits, they are urging the trial court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. And that's Hernandez v. State.
That's where they're saying there's a structural error. So the denial of the right to present a defense. So, and I'm just saying that the key terms there is a constitutional error from which prejudice is presumed. So let's see them flesh it out a little more.
Okay, holding the burden switches to the state to rebut the presumption by the showing that the error was harmless beyond a reasonable doubt. So that's what they're talking about with that.
All right, so that's, again, that right there is not a structural error then, because the structural There is no balancing. There is no proving it was harmless. It's always, always prejudicial.
Okay.
So
Similarly, exclusion of, quote, the evidence tending to show that someone other than the accused committed the charged crime, end quote, is, quote, inconsistent with substantial justice and therefore cannot be deemed harmless error, end quote. Again, that's not structural error.
right, but let's maybe it was just a use of the term, but yeah, there are also things like they're indicating here that it's on the burden of would be presumed prejudicial, so someone would have to establish that it's not a harmless error, which is also a very strong, strong burden in the law.
It is, but just like I kind of was reading. So like structural error means you're automatically getting a new trial. That's it. Like
Yeah.
there's no debating it. So if they find that structural error occurred, you're getting a new trial. End of story. End of conversation. Harmless error, that's much more of a balancing act. And that, that's going to really be left to the judges in terms of, and that's typically what you get, like on appeals. That's typically the evaluation that they're making, whether or not it was harmless error. So, all right. So thus the question becomes, what type of evidence is so critical and unique to Mr. Allen's defense that the U.S. and Indiana constitutions, above and beyond the Indiana rules of evidence, require its admission? The Indiana courts have answered that question by reversing cases when the excluded evidence challenged the credibility of the state's investigation and witnesses, presented an alternative exculpatory explanation of the state's evidence, Moore v. State, or showed that someone else could have committed the crime, Allen v. State, a 2004 case. Obviously not the same Allen. At the hearing on the prosecution's motion in limine, Mr. Allen presented evidence that the murders of Abigail Williams and Liberty German have ties to Odinism and were ritualistic. Mr. Allen also presented evidence that third parties are linked to the murders. The prosecution seeks to exclude, quote, evidence of third-party motive that is not relevant and or probative, or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401, end quote, from his motion in limine. Do you have a thought there? I thought I heard something.
Well, no, I mean, that's just kind of like what we talked about before. There's the defendant has a right to put this stuff on. It's not like, you have to meet this burden for third party culprit evidence before you can put it on. But there's certain aspects of a third party defense that you need to reach a certain burden before you can put certain types of evidence on. So, and I'll let the memo flesh it out more because I'm sure that it will. But there's certain aspects of accusing a third person or identifying that there were leads not followed up on through the investigation that just happen as a matter of course through cross-examination, that you don't need to meet some sort of magical, initial burden for. But then
and it's like I was talking about, like there's a connective tissue between the argument that it was an inadequate investigation and third party culprit thing, because they go hand in hand, right? I mean, it's that thing. Well, had you done a little more investigation, had you not developed tunnel vision, had you not focused on one individual to the exclusion of everybody else, you would have realized this. You would have found the evidence that you needed. You know what I mean? So that those arguments almost always go hand in hand. The prosecution further requests, in order to exclude testimony or evidence concerning A, Odinism, B, cult or ritualistic killing, C, Brad Holder, D, Patrick Westfall, E, Johnny Messer, F, Elvis Fields, G, Ned Smith, H, Rod Abrams, I, Keegan Klein, J, Jerry Anthony Klein, and K, Ron Logan. The prosecution requests seek to limit Mr. Allen's ability to present a defense and, if granted, violate Mr. Allen's rights pursuant to the 6th and 14th Amendments of the United States Constitution and Article 1, Section 12 and 13 of the Indiana Constitution to confront and cross-examine witnesses and to present his defense. I, Roman numeral I, Mr. Allen is entitled to present evidence pursuant to the 6th and the 14th of the U.S. Constitution, Article 1, Section 12 and 13 of the Indiana Constitution, that the crime has elements of Odinism and ritualistic killings. So the 6th and 14th of the U.S. Constitution, Article 1 and Section 12 of the Indiana Constitution, demand that the jury hear all versions and possibilities regarding the alleged crime. Again, Moore v. State holding it was a constitutional violation to prohibit the defendant from introducing suicide note near body and allowing state to introduce death certificate stating homicide. The state cannot take advantage of the inculpatory conclusion, but prohibit the defendant from placing the exculpatory conclusion before the jury. Turney v. State, Indiana case out of 2001 case. Holding otherwise inadmissible evidence that third party previously molested the victim was admissible as alternative explanation for the victim's injuries.
Okay, so let me explain that, because that's the type of thing, okay? If you want to get an evidence that a third party did something wrong before, prior bad act, now you have to reach that initial burden. You have to make that preliminary showing that there's a connection, that there's, that there's something actually there that has teeth before you can get it on. However, if you are talking about alternative explanation for a victim's injuries, um, it may seem conceptually the same, but that's different. So you're not using it just to show this guy could have done it, but maybe there was something about the specific injuries that was similar to the way that the other party had previously molested a victim, or that it seems here what they were arguing is this person has previously molested the victim, so that could explain the victim's injuries. Now, although it's very same, like I said, conceptually, as saying it could have been this guy that did it, and that's the only reason for this reason I'm putting in this evidence. The actual reason under the law makes a difference. Like when they talk about, not being able to put on other evidence of crimes to kind of dirty up the defendant, to show that the defendant is the kind of person who could have created, who might have committed this crime, because look at all the other crimes that this person has committed. No, you can't get it in for that. But if you're trying to get it in to show, well, lack of mistake, motive, something like that, which at the end of the day kind of has the same effect, the law says, well, you're putting it in for this other reason. There's actually another reason other than simply dirtying him up, even though it does happen to dirty him up. So to get it in, again, the point being to get in something to say that one of the third party suspects here has, committed a crime in the past or done something in the past, that you're going to need to reach that initial burden for. But to just get in kind of the stuff around him that makes him seem like he could have committed the crime, that you can get in.
All right. In this case, the prosecution argues that Richard Allen, acting alone, killed Abigail Williams and Liberty German. However, the evidence from the location where the bodies were found strongly suggests that more than one person was responsible for these murders. Former Indiana State Police Detective Kevin Murphy testified that it was always the belief of law enforcement that there were between 2 and 6 people involved in the murders. If the prosecution's argument is that Richard Allen acted alone, and there are alternative theories that the murders were committed by more than one person, then who are the additional people involved in killing Abigail Williams and Liberty German? The answer is that there are third-party suspects who have not been charged and who have no ties to Richard Allen. This leads to the conclusion that Richard Allen is innocent and that other individuals acting together killed Abigail Williams and Liberty German. Now, you have to presume that those individuals that they named are the ones that did it, like to make that argument that there's no link, at least through the devices, right? I mean, could it be somebody entirely different that is linked to Richard Allen, right? I mean, like that's the counter argument for the state.
Yeah, but they both get to put that, they both get to argue that.
Which is ultimately what this question is. Like that's what this issue is admissibility, and it's certainly admissible. It should be a question of weight, and that's up to the jury. How much weight they're going to give whatever they're going to put on in terms of third-party culprits. So Dr. Dawn Perlmutter, the director of Symbolic Intelligence Group and an adjunct professor of forensic medicine at the Philadelphia College of Osteopathic Medicine, who trains federal, state, and law enforcement agencies, testified that the murders were committed by individuals with ties to racist Odinism, sometimes also known as Asatru. I have no fucking idea how to pronounce that. Odinism and Asta. How do you think you pronounce Astatru?
Asatru.
But there's a T. Astatru.
No, it's after the A though. Asatru.
Oh, well, it's spelled two different ways if you look.
Oh, then Astatru. Spelled correctly, it's Astatru.
How do you know which one's correct? I don't know. Okay, so
know.
whatever. I'm not going to get all caught up in the typo. Our polytheistic ideologies involving the worship of Nordic pagan gods, including Odin and Thor. Asatru. All right. Thank you.
Awesome.
Asatru.
Right.
Okay. These ideologies are nature-based ideologies, and the rituals generally take place outdoors, incorporate natural elements, and are typically performed near bodies of water. Both ideologies incorporate the use of runes, which are marks of mysterious or magical powers. Runes take on additional magical powers when charged by blood, or I feel like I'm playing Magic the Gathering when I'm reading this. When charged by blood, or when two or more single runes are coupled together. That's the thing about this is like people read this and they're like, what the fuck are they talking about? It's just
right. Like you've always said, it's more the fact that the person, I think the evidence strongly suggests the person or peoples involved in this have ties to what she's calling racist Odinism or Asatru, because they had knowledge of things related to that. Whether this was actually a ritualistic murder, there were ritualistic, signs around.
Symbols, right? The rune, right. I mean, and again, that is going to go to the weight. And I'm just going to say, sitting through the 3 days of the hearings, they were very careful. The people in the gallery did not see the crime scene photos. And I imagine that during the trial, it's going to be more of the same. They're very protective of the families and their feelings, and they don't want, so I imagine they took great care to not make these visible to the gallery. So, theoretically, we're going to be going through this trial as observers of the trial and still not lay eyes on these crime scene photos. So,
right, well, the ones without the bodies in it, I'm sure you will.
I don't know.
Well, that would be silly.
Well, Baldwin was putting up, what were essentially drawings of the crime scene. They weren't showing any of it, but I mean, that's yet to be determined. I mean, that could be one of the things that they're dealing with on the 23rd. I don't know. That's close. Okay. Runes take on additional magical powers when charged by blood, or when two or more single runes are coupled together to create a bind rune. Both ideologies also incorporate magical thinking. In the magical thinking part was kind of the thing that I found most interesting about Perlmutter. I'd never heard of that terminology. And when she gave the kind of the analogy to just prayer, when you pray, that's a magical way of thinking. Your faith is telling you there's a God, but none of us know. Like, that's the one thing that I'm not going to argue about. Like, none of us know what happens when we die. But people that have faith in their religion and they subscribe to the tenets of that religion, when they pray, they're expecting or hoping for a result from that prayer. In the way that she put it, she's like, that's magical thinking. It's the same thing for these folks when they're creating runes. When they create a rune, they think that, and they activate it, they think that there's going to be, or they hope that there's going to be some kind of benefit to that person from the creation of that rune. So that kind of put it together for me, just in terms of a way of thinking, because and what was, and I know there's out there, they're like, she was a joke. I'm like, dude, she's educated. She trains the feds. She trains stadies. If she's good enough for law enforcement to hear it, I just, you can't dismiss her as being a joke, and she primarily testifies for the state, by the way. So both ideologies also incorporate magical thinking. Dr. Perlmutter further testified that while Odinists have general shared symbols, such as Odin's hammer, as they splinter off and form different kindreds, they often develop their own symbols and rituals. Social media has been a large part of this development, as it allows individual access to a wide range of interpretation symbols and ideas relating to the Asatru and Odinism. Perlmutter testified that the murders of Abigail Williams and Liberty German meet all the elements of a ritualistic killing, and that it was, quote, textbook ritualistic killing. The elements of the ritualistic killing include, one, the location of the crime. All right. So this is like, they're literally restating the testimony. I was hoping we were going to get a bunch of law here, and like, they're just restating exactly the testimony that came in.
They'll get to it, hopefully.
Okay. The location of the crime. Perlmutter testified that Odinism and Asatru are nature-based ideologies. His murders took place outdoors in a clearing in a wooded area near a body of water. Perlmutter testified that in Odinism and Asatru, clearings can be the location of the sacred circle where rituals and sacrifices take place. She further testified that it is important that the murders took place near a body of water, as water is often used for purification prior to rituals or sacrifices. Date of death. Now, I thought that this was interesting. Perlmutter testified that often rituals and sacrifices take place on important dates. She testified that Valusblot is a sacrificial feast day honoring Odin's son, Valus. This begins at sundown on February 13th and ends at sunup on February 14th. Liberty German and Abigail Williams disappeared on February 13th, 2017, and were found on the 14th, 2017. Right. That's exactly what I did in court when she said it. Dr. Perlmutter.
Explain why they waited to
after 2:30 to 3:30. Right.
Dr. No, I mean, like, might have waited to actually commit the actual offense, like kept the
right until after 2:30 to 3:30, because it had to be after sundown. We're saying the same thing. Dr. Perlmutter testified that ritualistic crimes are most often committed by sharp force injury to the neck, and that slitting the throat is indicative of sacrifice and an initiation ritual. Both girls were killed in this manner. Okay, and that's from Defendant's Exhibit, the autopsy of Roland Core. 4, murder weapon. Dr. Perlmutter testified that ritualistic crimes are often committed with ceremonial knives. The weapon used to kill the girls was a knife. And that comes from the autopsy report. Symbols of the crime scene. Dr. Perlmutter testified that in ritualistic killings, symbols including runes are often left at the scene. In this instance, there is what can be interpreted as a Laguz rune painted or transferred to a tree with Liberty German's blood. Now, this is the evidence that their blood spatter guy adamantly put forth an alternative explanation of what that blood on that tree was. So this tree is located near the area where the girls' bodies were ultimately found, on the edge of the clearing. Additionally, Perlmutter testified that the sticks and branches laid on the bodies appeared deliberately and intentionally placed in particular arrangements, which would have meaning to the individuals committing the crime. FBI agent Nicole Robertson testified that when she was searching the home of Ron Logan, she was looking for evidence of runes and anything Nordic due to the placement of the sticks on the girls' bodies. The depth of Nicole Robertson, page 75. The emails between the FBI and the state police superintendent Doug Carter all provide evidence of the belief by law enforcement that the evidence left behind at the crime scene, including the sticks found on the girls, supported the possibility the killers were Norse paganists.
I'm sorry, but the judge is not. I strongly believe the judge is not going to be able to exclude evidence about Odinism, Asatru. I don't see how they would do it. It's not third-party culprit. It's a theory of the case, and they are allowed to present their theory of the case without identifying any specific person, whether they knew anyone who's ever even practiced Odinism or Asatru.
Right, because I mean, again, ultimately,
That's not third culprit evidence. That's just
Correct.
their
That
theory of
that
the
is a
case.
theory, right? That's a theory of the MO, right? The modus operandi, like what, like why they were so. And again,
Or
the
they're
jury is going to see the crime scene photos,
right,
okay, and it's going to ultimately be left to them to give either this theory the weight or
right.
the weight that their expert put on in terms of saying, okay, well, if you stood across on the other bank of the creek or the river, if you looked over there, what they had put on top of the girls in terms of sticks and limbs, they were difficult to see. So like his thing was there wasn't much, but it was enough if you're from a distance that you wouldn't see the girls laying there. Like
Right,
that
and if you
that
come
their
back
theory.
and watch the Tellez trial with us, it's not like that they need the judge's, a permission to present some ridiculous theory that the, that the people associated with the Compass Realty wanted him out, and they conspired with the police to frame him. I mean, it's the same thing that happened in Karen Reed. You can get your entire theory in, whether or not it qualifies,
Yeah, for
rises to
for
the
those
level.
of you that think that Allie and I are always about all the conspiracy theories and frame ups, come and watch Tell Us with us. We're definitely this is like in my estimation, it is the worst frame up theory that I've ever heard. And I can't wait until Tell Us, if he decides to go and testify on his own behalf, tries to push this theory out. It's going to be
So
must
join us in 2
watch.
hours for that, because 'cause we're on a tight
Well, he's
schedule.
not testifying today, but they
Well, I
are
know
rolling.
for
They're
the
rolling
trial.
through their
Yeah.
witnesses pretty quick. All right. So number 6, the body disposition. Perlmutter testified that in ritualistic killings, bodies are often moved and positioned in a fashion that is not a counter forensic measure. So, in other words, that the bodies are moved and positioned in a manner not consistent with someone who is trying to conceal the bodies. She further testified that bodies are often positioned to include the arrangement of natural objects. In paragraph 6 of her affidavit of probable cause for the search warrant, I think it's supposed to say in the affidavit for probable cause for the search warrant for the Roman. Oh no, it was Nicole. So it was. So in her affy for the probable cause for the search warrant of Ron Logan's home, Nicole Robertson testified that it was her belief that Liberty German and Abigail Williams' bodies had been moved and staged. Major Cicero of the LaPorte County Sheriff's Department, he was their blood spatter guy, also testified at the hearing that Liberty German's body was dragged around the crime scene and that Abigail Williams was moved from side to side. Additionally, it is evident from the crime scene photo identified as Exhibit FF that sticks and branches were deliberately and intentionally arranged on the bodies. Cicero testified that the sticks and branches maybe covered 3%. Good. I got clarification on that because somebody was like 30. I'm like, nah, it was, he started at 5 and went down to 3. So I was accurate on that one. 3% of the girls' bodies. He further testified that there were many leaves and sticks in the area, which could have been used to conceal the bodies if that was the intent of the killers. And then 7, atypical blood pattern. Finally, Ms. Perlmutter testified that there is often atypical blood patterns identified in ritualistic killings. She identified the blood pattern on Liberty German's face as an atypical blood pattern. This abnormal blood pattern on Liberty German's face was also identified by Major Cicero. So Mr. Allen has a constitutional right, pursuant to the 6th and the 14th of the U.S. Constitution, Article 1, Section 12 of the Indiana Constitution, to present evidence describing the area where the bodies were found, the manner in which they were found, and to provide an explanation for said descriptions. I think we both agree that they do have that right to do that.
Absolutely. I don't see how the judge can not allow that in.
That would be insane. He further has the right to present evidence flowing therefrom. And again, like Ali said, that is not at all having anything to do with the concept of third-party culprits. That's just merely talking about theory of why the crime scene looked the way it looked. So he further has the right to present evidence flowing therefrom that the individuals who killed Abigail Williams and Liberty German were followers of Asatru and Odinism, and the murders were part of a ritualistic sacrifice. Roman numeral 2, the 6th and 14th of the U.S. and Article 1 and Section 13 of the Indiana Constitution protect Mr. Allen's rights to challenge the manner, quality and thoroughness of the investigation. This is what I was talking about, to inquire about law enforcement's failure to consider third-party suspects and to present evidence of a biased investigation. So Mr. Allen has a fundamental right under the Due Process Clause of the 14th and the United States Constitution, the Confrontation Clause of the 6th Amendment of the U.S. Constitution, and Article 1, Section 13 of the Indiana Constitution, to call law enforcement officers as witnesses and to cross-examine them on third-party suspects, as the failure to properly investigate or consider third-party suspects undermines the thoroughness of their investigation. And that's Heiser v. State, Bolds v. State, Pruitt v. State. The fact that an investigator may have discounted a viable fact or suspect makes it more probable the investigation was flawed and that Mr. Allen is innocent, thus meeting the requirements under the of relevancy under Indiana rules of evidence 401 and 402. Mr. Allen also has a fundamental right to impeach the credibility of and present the bias of any witness, including law enforcement. Quote, a witness's bias, prejudice, or ulterior motives are always relevant at trial, in that they may discredit her or affect the weight of her testimony. End quote there. Shanholt v. State. It has been well established that law enforcement, like all humans, can suffer from confirmation bias and tunnel vision. In other words, a detective or officer may search for and interpret evidence in a manner that confirms his or her existing beliefs. B. Coulter and Professor Keith Finley, Conviction of the Innocent, Lessons from Psychological Research. In this matter, Mr. Allen's evidence is that law enforcement failed to properly investigate third-party suspects and failed to consider alternate theories to their timeline. Now, I don't necessarily know that's true. I mean, the fact that they ultimately, initially, all thought, it can't be argued that they thought that the crime scene was strange enough to have found the Purdue professor, right? Turco. They went to him. So they didn't immediately discard it, but they discarded the concept in rather short order, which is one of the reasons that I'm still very anxious to hear from Turco. And we haven't seen witness lists as of yet, but I'm assuming that Turco will be testifying on behalf of the state. So, to say that they never consider it, I don't think is accurate, because I think that they did initially. And I think that ultimately they rejected it. And then you have Ferenczi, Click, and Murphy, who elected not to discard it and continue on with that investigation for years, a couple of years. In this matter, Mr. Allen's evidence is that law enforcement failed to properly investigate third-party suspects and failed to consider alternate theories to their timeline. That's a different issue. That's a different issue. The timeline, if y'all watch any of our thing, that's where I think that this attack should be in terms of defending Richard Allen, is the timeline, the 2:30 to 3:30 timeline that the state is locked into, pursuant to I think it was, who testified to it. I think it was Holman. I think Jerry Holman testified that they are absolutely confident that it was the murders took place between 2:30 and 3:30. Don't start yawning, because I'm about to tap you in to read, sister. In this case, members of the Unified Command failed to follow up on leads and investigations of Assistant Police Chief Todd Click and Indiana State Police Detective Kevin Murphy, such as the failures to perform an extraction of Brad Holder's phone, the failure to investigate the alibi of Patrick Westfall or Elvis Fields, and the failure to seek warrants to search the homes of those individuals. Unified Command did not consider any fact that did not fall into their timeline that the girls were murdered between 2:14 and 3:30 p.m. He moved it up to 2:30 to 3:30. I don't even know why they're giving him the extra 16 minutes. He said it on the stand under oath on February 13th of 2017. Unified Command failed to investigate why Liberty German cell suddenly connected to the cell phone tower at 4:33 a.m. on February 14th, 2017, after not connecting to the tower from 5:44 p.m. on February 13th, 2017 until 4:33 a.m. on February 14th of 2017.
Sun's probably down at 5:44.
Yeah.
Right? I don't know. February?
if it's not, it's very close to being so, because it's still not daylight savings time, and it's winter. It's still winter, so I would assume that's a really easy thing to check whether or not sun was down at that point. So Indiana State Police Detective Jerry Holman testified there was no evidence that Richard Allen returned to the location where the bodies were found after 3:30 p.m. on February 13, 2017. Something happened at 4:33 a.m. on February 14, 2017 that caused Libby German's cell phone to suddenly connect to the cell phone tower. And it is logical to believe that whatever caused the phone to connect was the result of actions taken by third-party suspects. The evidence goes to the very heart of the thoroughness of the investigations into the deaths of Abigail Williams and Liberty German. Mr. Allen's constitutional rights require that this evidence be admitted. All right. Can you read it? Can you take it? Or do you want to pull it up on your...
Are you starting at 3?
Yeah, Roman numeral 3.
I'm popping it up on my end.
Okay. I'll follow along and scroll for those who are reading along with us. So Ariel says sunset was at 5:12 on February 13th, 2017.
There you go.
Thank
There
you, Ariel.
Go. Wait, it's 3 on page. Oh yeah, I got it.
Page 9.
You guys can see it. I should make it a little bigger before Is that good?
A little bigger.
Little bigger. Hold on.
As long as it still fits on the screen there. Too big.
Is that as big as I can go?
You're still losing a little bit of the... Yeah, there you go.
Oh, I have to scroll on my side. Okay.
Yeah.
All right. 3, the 6th Amendment to the United States Constitution and Article 1, Section 12 and 13 of the Indiana Constitution protect Richard Allen's right to present evidence that someone else committed the crime. Evidence is relevant when it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. That's Indiana Rule of Evidence 401, same as the federal rule, same as almost every state. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. They cite Joyner v. State, a 1997 Indiana state case. In order for the defendant to admit evidence that a third party is responsible for the crime, the defendant must show some connection between the third party and the crime. Now we're getting into what the specific rule once you're rising to the level of identifying a specific third party. And that's Pelley versus State, a 2009 Indiana state case. When the state excludes competent, reliable evidence that is central to the defendant's case, his constitutional right to present evidence, I was expecting to say defense, but is abridged. Again, that's Joyner v. State in a 1997 Indiana case. Indiana courts have found the following evidence to be competent and reliable evidence central to the accused's defense that someone else did it. For instance, in Allen v. State, that's a 2004 Indiana case. Why that one says, maybe the other was Supreme Court where it just says Indiana 1997, and this is an appellate court. So an Indiana appellate case in 2004, the defense provided a reconstruction of the crime and testimony that another person made statements linking himself rather than the defendant to the murders, which should have been admitted. In Joyner v. State, evidence that a married man was having an affair with the victim, worked at the same place as the victim, the defendant had sexual relations with the victim the night before the murder, lied to his wife about his whereabouts, had an argument with the victim on the last day she was seen alive, and had lied on his time card at work the day after the murder was admissible. So that's all the things there that constituted enough to show that connection. In Rohr v. State, Indiana 2007 case, evidence that a prior beating of child victim by mother, not defendant, caused victims extensive injuries was admissible. Now, I'm going to say Kuki, Kachi, I don't know, v. State, and it's a
Cocky?
1985
Oh,
case.
I'm sorry.
Evidence of a newspaper article with a picture of a person wanted in connection with burglaries in the area and who resembled the defendant was admissible. I mean, as it
Should be.
should be.
Right.
Understanding that evidence of third-party suspects is relevant, the question then turns to the standard the court must utilize it in determining whether the third-party evidence is admissible. As the Indiana Court of Appeals has stated, to be admissible in a criminal prosecution, evidence that a third party has committed the crime with which the defendant is charged need not show substantial proof of a probability that the third person has committed the act. It need only be capable of raising a reasonable doubt of the defendant's guilt. While a criminal defendant may present alternative perpetrator evidence at trial in order to cast doubt on the defendant's guilt, the defendant must first lay an evidentiary foundation to establish that the alternative perpetrator evidence has an inherent tendency to connect the alternative perpetrator to the actual commission of the charged crime. And they cite Tibbs v. State. And then that Amjur evidence is a just like a legal writing, like a
American jurisprudence. Yeah.
American jurisprudence.
Right.
Here, Mr. Allen's evidence of third-party suspect falls well within this category of competent, reliable evidence central to his defense that he is innocent and that other people committed the murders. Mr. Allen's evidence has an inherent tendency to connect the third-party suspects to the commission of the crime. Start with Brad Holder. Brad Holder is the father of Logan Holder, and who was Abigail Williams' boyfriend at the time of the murders. Law enforcement identified Brad Holder as a suspect by February 17th, 2017, 3 days after the bodies were discovered. And they cite the defendant's Exhibit E to the motion to dismiss, hearing July 30th. Law enforcement received several tips that Brad Holder was the man in the video found on Liberty Germain's cell phone. German, sorry. I always want to stick an E at the end there.
I mean, germane is in your defense, is a word that we use frequently in the law. So,
but
I
also
get why you make the mistake.
That the fact that there were several people that called in tips on Brad Holder, they also going to have to work around hearsay. But I think there's workarounds for it. But anyway, purportedly taken at the south end of the Monon, what is it, babe? Monon High Bridge at 2:13 p.m. on February 13th, 2017, and that he was involved in the murders. Memo in support of the accused motion for a Franks hearing. I'm going to suspect that that's one because I think, there's so many now. But anyway, page 81 to 89. In his first interview with law enforcement on February 17th, Brad Holder told officers that he never met Abigail Williams. And that's a lie, just like you saw the husband lie to the wife in the case before. In his second interview with law enforcement on August 30th, Brad Holder claimed that he had difficulty remembering which girl that Logan dated, despite the fact that the girl Logan dated had been involved in a high-profile murder case. In this second interview, Holder now remembered that he had supervised one date between Logan Holder and Abigail Williams. Brad Holder then told a third different story as to how many times he met Abigail Williams when he was deposed on May 2nd, 2024. Deposition of Brad Holder, page 19. In his deposition, Brad Holder claimed that he met Abigail Williams twice, including once at a third-party suspect Pat Westfall's house. It's also important to note that Pat Westfall never admitted to the police that Abby Williams had been to his house. Cites the memo in support of the Franks hearing again, Exhibit 39, and page 99 to 101. Richard Allen has the right to have the jury consider the following about Brad Holder's second statement on August 30th, 2023, and whether his second statement and his deposition 9 months later, both providing different accounts of his interactions with Abigail Williams, tend to show that he is a third-party suspect. Should say, I think, tend to show his connection to the case, and that, you want to go back and use that initial language that the court used. So, um, had, uh, to connect the alternative perpetrator to the actual commission of the time of the crime charged. Um, oh, sorry, guys. Should just left it and kept going. Okay. So, 1, whether Brad Holder lied in his first interview on February 17th, 2017 to inoculate himself against being a suspect by denying having met Abigail Williams. This is inconsistent with his statement on August 23rd, 2023, and with his deposition testimony that he met her twice. 2, the validity or lack of validity of Brad Holder's initial claim that he had never met Abigail Williams in his February 17th, 2017 interview, 3 days after she was murdered or found, but then somehow was able to remember 6 years later when interviewed on August 30th, 2023, that he had in fact met Abigail Williams one time. 3, the likelihood that in 2023, Brad Holder would not know which of the murdered girls his son dated following the media coverage from this high-profile case, or whether his claim to not remember which girl his son dated was simply another attempt at Brad Holder to feign ignorance of his knowledge of Abigail Williams to throw law enforcement off his scent as a suspect. 4, the likelihood that Holder's ever-changing stories of meeting Abigail Williams, including his last story that he met her twice, once at Pat Westfall's house, is indicative of a man who can't keep his stories straight and only changes his stories because he is unaware of law enforcement's evidence of those meetings, causing Holder to step closer to the truth with every account he tells. Why would Pat Westfall choose to not tell law enforcement that Abby Williams had been to his house, as Brad Holder claimed in his deposition? And does such omission show that Westfall was concerned about being connected to Abby Williams? In the course of the investigation, law enforcement found Brad Holder posted many pictures of runes in his Facebook and discussed their symbolism and magical powers. His Facebook posts indicate that he believes in the magical power of runes. And they cite defendants exhibit II, KK, and LL. Even more revealing are Brad Holder's own words in which he admits that runes hold magical properties. Deposition of Holder. Brad Holder liked a post describing an outdoor sacrifice with a rune painted in human blood on a tree. Exhibit RR. Brad Holder also posted a picture on Facebook depicting a scene eerily similar to that of the bodies when they were found. Defendant's Exhibit SS. He intentionally inscribed a temporary tattoo on his hand in a pattern similar to the sticks and branches placed on Abigail Williams. Defendant Exhibit JJ. Even retired Indiana State Police Detective Kevin Murphy admitted that the sticks placed on Abigail Williams' body matched the temporary tattoo that Brad Holder inked on his hand just a few weeks after the girls were murdered. Furthermore, Holder painted and then posted a picture of Odin's sacrifice, in which a Norse pagan god, Odin, is hanging upside down on one leg, is bent in such a manner that his foot is resting against his calf. The position of Odin's leg in Brad Holder's painting is almost exactly the position in which the killer placed Abigail Williams' legs. Defendant's Exhibit NN. Brad Holder believes in the power of magic and blood as it relates to magic. This is evidenced by his Facebook posts, as well as Amber Holder's testimony that Brad intentionally cut his hand and allowed the blood to drip on his Odin altar. Now, That right there is also hearsay. Well, not the fact that he well, not the fact that he cut his hand and allowed it to drip on the altar. No, not that is not. Okay. Amber Holder testified that Brad Holder took her hand and cut her hand to drip the blood onto the altar. Major Pat Cicero, is that how he pronounces his name, babe?
Who?
Cicero? Pat
Yeah.
Cicero?
Yes.
Okay. Testified that the marking found on the tree, Exhibit 00, near the bodies was transferred to the tree with Liberty German's blood. Dr. Perlmutter and Major Cicero testified that the markings on the tree appeared to be an upside-down L. Dr. Perlmutter testified that this resembles the rune Laguz. Dr. Perlmutter testified that the runes, quote, charged by blood carry additional importance and magical powers, and that the blood is the highest offering to the god. The Norse pagan ritual videotaped by Brad Holder in Fort Wayne clearly showed Pat
Paul
Westfall
Westfall.
using his hand to mark the tree in some fashion, similar to the Facebook post referenced earlier, which was marked with human blood and which Brad Holder, quote, liked, meaning on Facebook.
So
Brad
let me
Holder,
jump in like real quick with a couple of things. So
sorry.
one, it appears that they've abandoned the F tree. I guess they're going to now call it the L tree. Because forever they were calling it the F tree. So that was obviously previous to both things happening, Perlmutter, and then I guess when they get Cicero's report. And the other thing which they excluded, which was frankly to me the most interesting aspect, was the fact that Holder had painted his own version of hanging Odin upside down.
No,
Which,
it's included in here. He
can
just
I
mentioned it.
finish?
Oh,
Can I
sorry.
finish? All right. So, but like in the original painting, it's the opposite leg that's bent. Okay, so the original painting has the opposite leg bent, and think of this picture of Odin is like the equivalent for Norse paganism as like, you know, the
Jesus on the
pictures
cross.
of Jesus on the cross, right? So it's a it's a very, very well known picture within that religion. And the interesting thing that I thought that Perlmutter noted is that both in Holder's painting, his recreation of it, and that Abby was placed with the opposite leg bent, that both of those things
That
took
is
place.
that
That
is
to me,
very telling.
I thought that was very, very interesting, and I'm surprised that they didn't bring it up, frankly. All right, I'm
Yeah.
done.
Okay. Brad Holder testified that one of the times he met Abigail Williams took place at the home of third-party suspect Patrick Westfall. Holder's deposition. Amber Holder, Brad Holder's ex-wife, testified that Brad Holder told her that Patrick Westfield and his crew murdered Abigail Williams and Liberty German. So that'll be a statement against interest to get around hearsay. Richard Allen has a Sixth and Fourth Amendment right to present to the jury these facts and to argue that Brad Holder was pointing the finger at Patrick Westfall to either A, insulate himself, Holder, as a suspect by implicating Brad Westfield, or B, that Westfall, or that B, Patrick Westfall, who had no real alibi, actually killed those girls, and Brad Holder knew it and wanted someone to know in the event that Holder was ever accused of the murders, or C, that Patrick Westfall, acting in concert with Brad Holder, had the girls abducted while Holder was at work, awaiting Holder's arrival in Delphi later, at which time they killed the girls. I would have added there until after sundown. They had to get somebody and then hold them till after sundown. So they had them for sundown. These facts and arguments, along with the knowledge that both Holder and Westfall are Norse paganists and the belief of law enforcement and expert witnesses that the crime scene was filled with Norse pagan elements, all tend to show Brad Holder and Patrick Westfall killed Abigail Williams and Liberty German, and therefore this evidence should be presented to the jury. Now, again, here I would not have gone as far as to say that it shows, all tend to show that they killed her. I would have said that they all tend to connect them rising to the level of the law that they cited before, comparing it to the other cases. This is more than what they had in this case. It is similar to that case in that it has all of this stuff, but that's really form over substance at the end of the day. But consistent with the low bar required to honor a defendant's constitutional right to present third-party suspect evidence, Amber Holder's August 1st, 2024 testimony exhibits an inference that Brad Holder and Patrick Westfall were involved in the murders. Amber Holder testified that she is Brad Holder's ex-wife and that Brad Holder confided in her and that he and Patrick Westfall had a falling out over something that happened in the woods near a river involving blood. That is also hearsay, so they'll have to work around that as well. Furthermore, Amber Holder testified that Brad Holder confided to her that Patrick Westfall and his crew killed the girls because of Westfall's belief that Abigail Williams' mom was a race traitor. Footnote 1, a race traitor is someone who supports attitudes or positions against the interests of or well-being of their own race. Okay, thanks for that. Dr. Perlmutter also testified that individuals adhering to the white nationalist version of Odinism would kill others because of the belief that someone was a race traitor. Furthermore, Amber testified that Brad Holder told her that Westfall wanted to move on from animal sacrifices to human sacrifices, and that this was the real source of the falling out between Holder and Westfall. Now you have hearsay upon hearsay, meaning Westfall said it to Brad, hearsay, Brad says it to his ex-wife, double hearsay. In this deposition, Holder denied ever making any of these statements to Amber Holder. Deposition Brad Holder. Brad Holder's denial of uttering those statements to Amber makes Holder's statements subject to impeachment at trial. Brad Holder's denial of uttering those statements to Amber.
That's from Holder's dep.
Right. So let's just think about this. If Brad testified at trial that he never made that statement, then Amber's testimony could come in to impeach him.
Right.
So I guess that it's the equivalent to the same. So, okay, agreed. Brad Holder's, but again, in order for that to happen, okay, because the law doesn't allow you to just impeach any old statement. It has to, if it's collateral, and if the judge finds that there's not a, again, we're saying that there's certain aspects of what they want to get in that the judge has to let them do. It's their defense, but then there's that other step that she's got to find that there's that connection for to get maybe everything in. So if the judge doesn't find that strong of enough connection, she may not allow him to impeach on what she would be calling a collateral issue, and just whether or not them showing so here's part of the problem, actually. So what you saw happen in the trial, and read if you happen to watch that trial, that was on cross-examination. When you're cross-examining a witness, you have the right to impeach that witness, show their bias, show their motive to lie falsely, all of those things. When you call your own witness, you can't call your own witness just to impeach that witness. I don't know how it works here when you have a deposition.
They've loosened on that stance quite a bit. They have.
Okay.
Like for instance, I mean, in Young Thug, they basically they called Woody knowing that they were going to be impeaching him. Like knowing.
Right. So that's what I was going to argue here, or point out that, in a typical case, you're like, well, I was calling to get in his substantive evidence. He denied knowledge of it. He forgot it, like Woody. So now I'm impeaching him. But in Woody, they knew he was gonna deny it ahead of time. And here, because like in Illinois, we are not allowed to do depositions in the normal course in a criminal trial. So we wouldn't already know the guy was going to deny it. So that might also be an issue here, that because they took the deposition, they know that the witness is going to lie. And should they be allowed to call him? Now that would might come into needing her to find that they met the threshold for third party suspect in order to do it in that manner. That's different than when the cops are on the stand asking them about their investigation and did they follow this person up and did they follow that person up and what about this guy because of the Odinist angle. They can do all that till the cows come home, but clearly the prosecution's not going to be calling Brad Holder, Amber Holder, Mr. Westfall, the boy Elvis, who I'm sure we're going to get into here. So, and when you've deposed everybody and it's clear you're going to be impeaching everyone, that might be another hurdle that they're going to have to address. Okay, so all right. So Brad Holder's alibi is in question because of 4:33 a.m. phone activity.
See,
Here's your timeline stuff, babe.
This is a criticism, right? So what that should say is that the timeline, in terms of the time of death, is in question because of the 4:33 a.m. phone activity, not Brad Holder, because Brad Holder's alibi then, as part and parcel of the timeline being in question, then his alibi then
Right.
comes into question. Like, to me, like, again,
Right,
form
exactly.
over
Exactly.
substance.
But I agree.
Yeah.
That heading could have been
But
worded.
they know who they're dealing with Judge Gull. She is going to be inclined to think this is all bullshit.
I don't see how. You have an expert. You have they have an expert. The judge can't disregard, what is it, Paul Mutter?
Perlmutter.
Pearl
So,
Mutter?
well, Travis asked Bob in the next pause would be interested to see what Bob's thoughts were on Perlmutter's general demeanor. Her demeanor was fine. How she generally did on cross, I think Nick made his points. I mean, Nick certainly made points in terms of, where does her knowledge base come from? Like what textbook are you talking about? Where is this? And she didn't really have answers for some of those questions. Now, she's in art history. She has a PhD, I believe, in art history. So, which is obviously not crime related, right? So, like, she's got this kind of interesting background in terms of how she'll come off to a jury. Ultimately, I think that the state is going to have a lot of fodder in order to be able to kind of frame her as a quack a little bit. That
Well, what
being
is she
said, I found her
training?
to be a very educated person. She came off as a very credible person. I mean, she's got the background in terms, I mean, you're going to have to rebut it with the fact that she typically testifies on behalf of the state, not defendants, and that she trains the feds and state officials, law enforcement officials, on this stuff. So, I mean, they think enough of her to take into consideration what she's saying. Again, she's getting on. They're not going to be able to exclude her as an expert, and it's going to go to the weight in terms of
Well,
whether or
especially
not.
because you said they don't have like a strict Daubert or Fry.
Right,
Well,
it's kind of a hybrid.
right, but so you're saying that the judge is not going to be able to deny that she qualifies as an expert under this because of her background.
Right.
And I just want to let you know, we are not cutting this into two. I'm going to keep going without you. So when you're leaving, just open up a new screen. Don't take, don't leave
Yeah.
this.
I'll leave this one.
Well,
I
don't
left
leave the
yesterday.
studio.
Yeah, I left the studio yesterday. It kept the stream was fine. As
Okay.
long as you're on, because you're, a co-boss here, like, it keeps going. So,
Okay. And I just figured it while we were stopped, we could click on some of these first. Let me actually thank Debbie. Thank you, Debbie. Bob can say $10 holla.
I already put that up. $10.
Oh, you did. Okay.
Put them
Akasha
both
says,
up.
being from Southwest Michigan, I can tell you for sure that there definitely are Odinists that are in the area, and they definitely are not to be fucked with. They need to stop acting like it is so far-fetched. And I, we did some research early on. There's definitely, and the defense did as well. I mean, there is no doubt you've got people with tattoos on their face now, and they had corrections officers tattooing their faces.
And look, and I can see why Baldwin is so entrenched in this concept, because stripping everything else away. All right. The fact of the matter is that all these guys are Odinism or Odinists. I don't even know if that's a real word. They all practice
Awesome.
Norse paganism. There's no debating that. It's a real thing. It exists in the world. All this noise that it's bullshit and it doesn't exist. It does exist. I mean, you just have to look at their Facebook shit to know that they all practice this. The reason why Baldwin just cannot move off of this stuff in terms of these guys being somehow involved is because of the timing of Brad Holder's Facebook posts, wherein no one knew, because law enforcement still to this day is so tight-lipped about what that crime scene looked at. For him to be posting things that were so similar to the way that the crime scene looked is why Andrew Baldwin just cannot, his brain will not allow him to get off of him. And I mean, and he's got a point. Whether or not that's ever going to reach the level that it's going to resonate with the jury, I have no clue. But I can understand why he's just obsessed specifically with Brad Holder. I mean, I'm far more obsessed with the kind of the Elvis Fields putting himself at the crime scene than I am Brad Holder. I mean, to me,
it doesn't need to be Brad Holder specifically.
I know,
Yes,
but
he's
I'm
thrown
just
in.
telling you that,
Right.
that Baldwin focuses on Holder more than anyone.
Right. And this sundown
And Holder has
situation,
a connection with Abby. Like that's like those two things are what have him obsessed with this thing, like far more than I believe that Brad is like you never hear Brad arguing this stuff in the hearings. It's always Andy. Like, this is Andy's baby. And then Brad handles the stuff with, he's going to handle the shell casing stuff and the confessions and those type of things, which is not unusual. I mean, Allie and I don't always see eye to eye in terms of how to approach a defense. And we're in the same office. You know, these guys have separate practices who are just paired together by a judge. And, you know, they're obviously going to have their own mindsets in terms of how to approach the defense of this case. And what I'm saying is Allie and I, who are not only, you know, partners in the law, we're partners in life. We're, you know, and we're very similar in the way that we think about things and view things. But there's been plenty of occasions where Allie and I have had complete disconnects on how we should approach a certain issue at trial in terms of a defense. So, I mean, that happens. And I think that ultimately what their challenge is that Baldwin and Rosie are both going to have to realize that neither one of them are willing to move completely off their theory of defense in terms of how they're going to go at it. And they're going to have to try to figure out a way to incorporate both within the same theory, which I think can be done, I
think so too. And as a public statement here, a public announcement or whatever you call that, Bob is not speaking from any personal knowledge of that he has.
I'm done acknowledging that.
I know.
Shit.
I'm just saying this is coming from the
ridiculous.
filings and what
Those
happens in
people are
court.
ridiculous. No, like I said, anytime they want to have me on and chat, I'm here for it.
All right. So, and again, as Bob's pointed out, this whole sundown thing, coupled with the phone activity, and the fact that the officers strongly believe this was more than one person, definitely speaks to Brad Holder not having an alibi. We don't know the timeline. And again, Bob's point is that should say, you know, the timeline is in question, so there's no way to establish Brad Holder's alibi. All right, moving on. Oh, and thank you, Kyle. Thanks for the deep diving, all things. I've learned so much from the both of you. Family hugs. Ooh, family hug.
Oh, you did it.
Is that right?
Aw, family hug. It was
Oh,
close, babe. It's the
okay.
thought that counts. It's the thought that counts.
Ah, all right, all right. Um, okay. Brad Holder's alibi is in question because of the 4:33 a.m. phone activity. Detective Jerry Holmans testified that Brad Holder has an alibi as he left work at 2:45 p.m. on February 13th, 2017 and was 40 minutes away from Mount Monon or Moonon, I'm sorry.
Monon.
Monon High Bridge. First Sergeant Chris Cecile of the Indiana State Police testified that the phone ultimately found under Abigail Williams' body did not receive any SMS messages from 4:06 p.m. on February 13, 2017 until 4:33 on February 14th, 2017. And I wonder why they specifically mention SMS. I mean, did she receive some text messages but not
Yeah,
SMS?
no, they're talking SMS in iMessages.
Right, but did she actually get some green ones, some text messages that were not
That
SMS?
yeah, that was the whole thing, but it wasn't the color. It was because there's a differentiation between what it reads is like for ours, it says when we're texting each other, and I forget which it is, but I'm going to look at our text. So for our green ones, it shows when it's sent as a text message, or in the blue ones. So where SMS is,
Oh,
it's
when
the
received.
opposite when received.
Okay.
So yeah, there was a differentiation. That was a thing that Auger and Cecil, their phone guy, were going at it for a half an hour. It was hilarious.
This suggests that Liberty German's cell phone was not connected to a cell tower at that time. Law enforcement's claim that the phone had remained under Liberty German's body, found around 3:30 p.m. on February 13th, 2017. Oh, from, sorry, I said found. My mind thought it said found as well. Okay, from 3:30 p.m. on February 13th, 2017 until it was found around noon on February 14th, 2017. However, cutting against that theory is the fact that a police report references Sergeant Mitchell Blocker's belief that the phone, as of around 10 p.m. on February 13th, 2017, was either no longer in working condition or that it was out of the area. We know from Chris Cecile that the phone was
Cecil.
working. Cecil,
Yep.
that the phone was working in working order because it connected to the tower at 4:33 a.m. on February 14th, 2017. Therefore, the police report supports the fact that the phone was out of the area for a period of time. In further support that a phone was out of the area is the fact that from 5:44 p.m. on February 13th, 2017 until 4:33 a.m. on the 14th, the phone in question did not connect to a tower in spite of law enforcement's claim that the phone had never moved from under Liberty German's body from roughly 3:30 p.m. on the 13th until the girls were found around noon on the 14th. Now, again, I have said they could have been using a jammer, and when the suspects left at 4:33 a.m., that the phone was no longer jammed. Could also be an explanation that also establishes that it could not, or points to the fact that um, Holder or whomever else, they would need an alibi for a much longer period of time. Okay. Liberty German's phone received no SMS messages from 4:06 p.m. on February 13th, 2017 until it received 15 SMS messages at 4:33 a.m. on February 14th. It defies all logic that 15 individuals suddenly sent SMS messages to Liberty German's phone at 4:33 a.m. Well, right, that no one thinks that happened. On February 14th, 2017, when she had been missing for over 14 hours. When Liberty German's phone once again connected with the tower, as Chris Cecil finally admitted during his testimony, all of those messages awaiting Liberty German's cell phone to connect to a tower finally matriculated onto Liberty's phone at 4:33 a.m. The simple explanation is that someone who was at the scene turned on that phone at 4:33 a.m., causing the phone to connect to the tower once again at 4:33 a.m. That is definitely one possibility. Again, I think the jamming possibility would be another. Um, and I don't think that it's unusual to assume that somebody might have turned on the phone because they wanted the bodies to be found. Jerry Holman testified that in law enforcement's theory of events, Richard Allen never returned to the crime scene after he left at 4:30 on February 13th, 2017. Therefore, who could have been at the scene at 4:33 a.m. to turn the phone on? Again, it was underneath her body, so nobody would have been able to do that after.
And again, like I just want to state this. So two things came out of that hearing that we did not know. So Chris Cecil, their phone guy, currently is running the most updated Cellubrite update, whatever you want to call their software update. So they're actually still waiting on that report. Like to this day, 7 years later, 7.5 years into this investigation, Cecil is now running on Libby's phone the most updated Cellubrite extraction. Okay, in order to see what that brings forward.
I would hope the new defense person would be wanting their expert to do it directly and on his phones.
And I also want to be clear that this issue of the phone apparently either somehow turning back on or for whatever reason it connects with that signal has nothing to do with phone location to me. I mean, does it seem to appear that phone was turned off and could have been taken away from the scene? Absolutely, it means that to me. But in terms of the fact that AT&T was pinging it every 15 minutes, I don't care about the location of the phone with respect to this issue. What I care about is the fact that it somehow turns back on, where when AT&T is pinging it for those 11 mystery hours, I find it implausible that the phone was on and operating, that the phone didn't connect to the signal that was closest to the crime scene, and those messages didn't flood in at some point during that 11 hours. That's what that means to me. So, like, because I had somebody tweeting at me, like screeching and yelling about pinging, and it's historical. It's gonna like none of that matters. What matters is, was the phone on or off? And if the phone was off during that 11 hours time, which would seem like logic would dictate that, right? Because AT&T was pinging the girl's phone in order to try to find them. Like that's what they do. Though, like when they're trying to find somebody, whether it be a suspect or whether it be victims, and they hit a provider and they're like, "Yo, we need you to please ping the phone, and we want you to do it every 15 minutes." So they'll ping it. They'll ping it. If it doesn't pick it up, it goes historically to the last place that it picked them up. That's not what we're talking about here. What we're talking about is that it didn't connect with the tower at all until 4:33 a.m. And something happened at that point in time. And what it seems to me is that the phone turned back on, and then it connects to the tower. And all of and again, like we're talking about iPhones here. Like we're like at trial, I am assuming we're going to be able to know what, but again, like whatever version of the iOS Libby's phone was, I have no clue. But again, that will be determined at trial. But I'm assuming that we're going to be able to see what the battery charge was at various times, at times that they know that the phone was on. Because one thing that does not happen is phones do not just regain battery power if they're not plugged in and being charged. So the concept that the phone died and then somehow magically the battery recharged just enough to turn the phone back on sounds like complete bullshit to me. I mean, if there's a phone expert out there and tells me that that's a thing, well, send me the proof, because short of that, I don't know how this phone turns back on other than it being manually turned back on by somebody. And that, and I just want to be clear about that aspect of it. So
Agreed.
muted to the point that you can't hear me, Akasha. I don't know. I mean, my mic is probably done. All right, babe, keep going.
Okay. Okay, Jerry Holman testified. Okay, we got that. Okay, we got that. If Abigail Williams and Liberty German were killed around 4:33 a.m. on February 14th, 2017, Brad Holder's alibi for 3:30 on February 13th, 2017 is meaningless, as his alleged alibi that he was at workout anytime at 2 a.m. on February 14th, 2017. The only time he has ever went to the gym at 2 a.m. So I would have just said here, instead of if they were unalived at 4:33 a.m., I would have said if the murderers, one or more of the murderers, were with Abigail Williams and Liberty Germain until 4:30 German, Jesus, until 4:33 a.m. Then his alibi is that those two times are meaningless. I mean, that you could have, different people involved, and they're all leaving at different times, to be alibied at different times during, throughout the whole time. Okay. These phone issues are a major problem for the prosecution's contention that Richard Allen acted alone and had left the area where the bodies were found by 3:30 p.m. on February 13th, 2017, and certainly provide the minimum nexus, along with the other evidence detailed herein, required to clear the hurdle that allows third-party suspect evidence at trial. And I just want to note here with this that this may speak to why they initially charged Richard Allen with kidnapping, because they believed he didn't act alone. He did the kidnapping, he left, and the remaining perpetrators committed the actual offense. Just a thought, though. Just a thought.
I just wanted to thank Courtney. She sent a $20 Venmo. Thank you very much. Thanks for all your work on Delphi. Thank you, Courtney, for your constant support. We really appreciate it. All right, here, let me read for a bit because I'm gonna dip here in a couple minutes.
Yeah, 1 minute.
I could be a couple minutes late.
I mean, I can read. You got to be back at 11. That we need you back.
No, we're going live at 11:20 because that's supposed to start at 9:30.
All right, do it.
All right, I'll do a little bit. Is my mic low?
I hear you fine, but I saw
said that my mic was low.
Right. So if anyone else is hearing something I'm not,
here, I'm gonna turn up my mic a little. See, but I'm on an automatically adjust.
No, you sound fine to me. I think that might have been her own issue.
Okay.
You're fine, Bob, says Spitfire.
Okay, thanks.
You.
All right, so Patrick Westfall, Brad Holder is connected with the other suspects in this case. One of the suspects is Patrick Westfall. Patrick Westfall was at home near the Monon High Bridge on February 13th, 2017 with his son, Nick. And that comes from Westfall's interview of August 27, 2023 at 11:56. And that also comes from the Frank's memo. I'm assuming, like Allison says, they're not delineating between which one. I'm assuming it's the first one since they're not doing that. There is no proof of Westfall's whereabouts on February 13, 2017, other than his statement. To date, law enforcement has provided no concrete evidence of Westfall's whereabouts on February 13th of 2023. Holder and Westfall knew each other from an army deployment in Afghanistan. No shit. Westfall and Holder practiced Asa True.
Or Asha True.
That's what I just said.
No, I think somebody said it might be. Okay, yeah. Asa True. Go ahead. I thought it might have been Asha True. Whatever. Sorry.
Are you done?
Okay. I am.
There were members of a small kindred, which is a group of people who believe in Asa True, who gather to hold meetings and worship the gods. And again, this is all coming from this interview. Patrick Westfall is a priest or a holy man in the Asa True religion and hosted kindreds at his home in Delphi on Sundays. Brad Holder attended these meetings. Same interview. Holder and Westfall attended a pagan ritual videotaped by Brad Holder in 2016 in Fort Wayne, Indiana, which is Allen County, which is where the jury is being imported from and where Judge Gull sits on the bench, which was entered into evidence. Near the end of the video, Patrick Westfall appears to be marking the tree with his hand. Major Cicero testified that a tree at the crime scene was marked with the blood of Liberty German. Perlmutter testified that the mark was in the form of a rune. Cicero admitted that whoever sliced Liberty German's throat could have Liberty German's blood on their hands. The forensic pathologist, but he also said that he believed that because Libby had blood on both of the palms of her hands, that as a natural instinct that when her throat was cut, that she would have put her hands up to cover her throat. And his theory is that she then, to stabilize herself, to steady herself, that she put her hand on the tree and that her hand went down the tree, creating what would be like the base vertical line of the L. So he has very.
And I'm going to say there's enough there with this expert to put both theories in front of the jury.
Oh yeah, both theories are going to get in front of the jury. Okay, so the forensic pathologist who conducted the autopsy admitted that upon slicing Liberty German's neck, the amount of blood and the force of that blood exiting Liberty's neck upon slicing would have been very powerful, squirting as far as 4 to 6 feet. And like, we should have given a trigger warning here because this is very graphic. Very graphic
Yes,
stuff.
sorry. Trigger warnings remaining.
Yeah. And that's from the deposition of Roland Core. Therefore, the jury.
Wait, footnote 2.
Where was that footnote?
Right before therefore.
No, I know, but like, where was it in the? I don't know where it was.
Right
up in the
here.
paragraph. Now, I know where the actual footnote is. What is it footnoting? Is what I'm asking.
Here, right here.
Okay.
I'll read the footnote. This deposition was not included during the evidentiary presentation and therefore is being provided via first-class mail.
Okay, so honey, what I was asking is where is the actual footnote in the document?
I was showing you right there before the word therefore.
Oh. I still don't see it, but never mind. Can conclude that upon slicing her neck, the blood forcefully covered the killer's hands, who then used that blood to mark the tree. Patrick Westfall told police that he had sacrificed a chicken by cutting its head off, or cutting off its head, and that comes from Westfall's interview again. Perlmutter testified that sacrifices are almost always carried out by slitting the throat of the animal or the person being sacrificed, and furthermore, that practitioners of these religions often begin with animal sacrifices. As mentioned earlier, Amber Holder testified that Patrick Westfall wanted to elevate from animal sacrifices to human sacrifices. Furthermore, Patrick Westfall acknowledges that Asatru worship takes place in the clearing of the forest. But just to get the other side out there, Amber also said that that in her estimation, they would never kill a human, and they would not. Well, specifically, they would never kill a child in a ritual. That children are sacred, and that they would never do that. That's why they use animals. So she's got inconsistent testimony that came out when she was on the stand. So this is consistent with Perlmutter's testimony that rituals will occur in open spaces in the forest. Both victims in this case were found in a clearing in the forest. This creates an inference that Patrick Westfall was involved in the murders of Abigail Williams and Liberty German, and that they were sacrificed in an Asatru Norgan pagan ritual. All right, so I'm going to dip. You read Elvis. I'll see you all later. See you guys at 11:20.
All right, Elvis Fields. Elvis Fields, a Rushville, Indiana resident, is a suspect in this case who was investigated by law enforcement. There is no doubt that Elvis Fields knew of the existence of Brad Holder. He admitted this as such in his deposition, and they give the page number. Additionally, Detective Kevin Murphy testified that Brad Holder can be linked to Elvis Fields through Facebook posts, and that Elvis Fields' Facebook posts mimicked those of Brad Holder's. And those would be exhibits KK, LL, and MM. Elvis Fields testified in his deposition that Brad Holder frequently mimicked his Facebook posts when he posted pictures of knives, brass knuckles, sticks in the woods, or other items. That comes from Elvis's testimony. Okay. I was just looking back to see who mimicked who. So Elvis was saying that Brad Holder mimicked Elvis's posts. Okay. It is a logical conclusion that Brad Holder knew Elvis Fields in some manner if he was mimicking Elvis Fields' Facebook posts. It would be exceedingly rare for a stranger to follow someone's posts, and even rarer to mimic them, especially when both people are suspects in the murder of Abigail Williams and Liberty German. And I giggle there because how often does somebody retweet a stranger's tweet on social media? Someone they're following on social media for whatever reason, and they agree with it. Happens all the time. But I'm not discounting their entire theory here. I was just saying. So, um, former Rushville Assistant Police Chief Todd Kleck testified that Elvis Fields was a suspect or accomplice in the murders and that he was interviewed several times by law enforcement. After one such interview, in which law enforcement collected a buccal swab from Elvis Fields, Detective Kevin Murphy drove Elvis Fields home. Detective Murphy testified that after Elvis Fields got out of his car, he returned and asked Detective Murphy if his spit was found on one of the girls, but he could explain it away. Would he still be in trouble? Elvis Fields lived in Rushville. He testified he was home in Rushville on February 13th, 2017. They cite to his deposition. He denied ever being in Delphi. Again, his deposition. If his spit is on one of the girls, this places him in Delphi at or around the time of the murders. Elvis Fields' statement is admissible pursuant to Indiana Rule of Evidence 8033, then existing mental, emotion, or physical condition. I think it's almost a statement against interest. But he's not a party, so I got to think about that. But anyway, here's the rule 8033. And again, it mirrors the federal rule and all the other rules. A statement of the declarant's then existing state of mind, such as motive, design, intent, or plan, or emotional, sensory, or physical condition, such as feeling, pain, or bodily health, is admissible as an exception to the hearsay rule. I find it odd. This is the only hearsay rule they tried to sort of counter here. I think I would have left it to be that if the judge finds these things are admissible, but that they would be otherwise inadmissible under another rule, that the defense would ask for the opportunity to present exceptions to any other evidentiary rule that the state or the court felt applied. Elvis Fields' statement is clearly indicative of a guilty state of mind and indicates he has a mental feeling of anxiousness over his conduct and possible ramifications. Okay, so I see how they tied that in there. It's a little bit of a unique argument, I think. So the statement is, if he spit on one of the girls, wait, let's go back to his statement. He comes back and he says, if his spit was found on one of the girls but could explain it away, would he still be in trouble? It's definitely going to his then existing state of mind, and also could indicate that he was nervous about the possibility of him being implicated. All right. So, additionally, Elvis Fields denied making said statement to Detective Murphy. And again, he cites his deposition. It is expected that Elvis will continue to deny asking the question at trial, thus making it proper impeachment evidence. Again, that would require them calling their own witness, and then for the purposes of impeaching him, and would also require impeachment through collateral evidence. I think that they could get this in through the officer as part of their investigation, and to show that they failed to follow follow up on that, and you could get around hearsay for some other way that way. I'd have to think about it though. Finally, Elvis Field's question to Detective Murphy was precisely that, a question. Quote, hearsay is a statement that, quote, is not made by the declarant while testifying at a trial or hearing, check, and two, is offered to prove the truth of the matter asserted. So that would be the argument that we're not trying to prove his spit was really there. We're just trying to prove that he was nervous about the possibility that that his spit was there, or that he could be tied to the offenses. Continuing on, a quote statement is a person's oral assertion, written assertion, or nonverbal conduct that is intended as an assertion, which that's what I was almost trying to think. Could the activity of slicing the blood and putting it over the whatever the Holder's ex-wife was describing, would that be nonverbal conduct? Nonverbal conduct is something like, where did we hide those drugs from the cops? And somebody points. So there's some nonverbal conduct. They stick up an umbrella, nonverbal conduct that it's about to rain. That one might not actually work, but anyway, the hearsay rule does not bar commands, requests, or questions. Huh. I think more should be argued about it not being for the truth of the matter asserted. Hmm. But I mean, that's also a point. He wasn't making a statement. He was asking a question, which then does go back to tying in to his state of mind. It is indicative of his state of mind at the time. So it's okay. Rod Abrams is a friend of Elvis Field's. In his statement to police, Rod Abrams testified that at the time of the murders, Ned Smith drove a white pickup truck, and they cite his dep, and that also sometimes Elvis Fields drove a white pickup truck. Tina Garrison saw a white pickup truck parked at the old CPS building near now I forget if it's Monhigh Bridge Trail at approximately 4:20 p.m. on the day of the murders. This Tina Garrison report was tendered near the end of the day as an exhibit on August 1st, 2024. Given that both Elvis Fields and his friend Ned Smith drove white pickup trucks, this potentially places them in Delphi near the scenes of the murders on February 13th, 2017. So now this goes to the requirements under the rule for the third-party suspects of, a connection to the crime, something that really establishes they might have done that. So, having access to a white pickup truck, making a statement like that, it's something. It's something. And obviously his connection to aspects of Odinism, we'll just say. Detective Kevin Murphy also testified that an analysis of Elvis Fields' cell phone records established that Elvis Fields used his phone often throughout a typical day. Strikingly, Detective Murphy testified that on February 13th, Elvis did not use his phone between 10 a.m. and 7 p.m. And that is compelling evidence, especially if somebody has a pattern. You'd need to know what was it that person was doing on that day to be different than all other days. All of the above is documented in Todd Click and Detective Kevin Murphy's reports. Statements made in a police report are not hearsay when offered to show the simple fact that the statements were made rather than for the truth of the matter asserted. And they cite to Heiser v. State, holding that a report made to DCS by the accused was offered to show that it was made just days before the child who lived with the suspect of the report accused the defendant of molestation, and not for the truth of the matter. The report was not hearsay, and its exclusion violated the Sixth Amendment of the United States Constitution. I can't imagine they believe that when they say the report was not hearsay, they don't, they're not referring to the written report. They're referring to the report that somebody made, like they called DCS, Department of Children and Services, and reported something. Um, Indiana Rule of Evidence 8038I states that investigative reports are admissible when offered by the accused in a criminal case. I wonder if that one is different, a different rule in Indiana, 'cause okay, moving on. Finally, the fact that Elvis, so I take it back, they are actually referring to the actual, police report, physical paper report in that Heiser v. State. Um Finally, the fact that Elvis's friends, Rod Abrams and Ned Smith, could not keep their stories straight concerning their whereabouts with Elvis on February 3rd, 2017 is also important. Now, I don't know what the ages of these people are. I thought my understanding that Elvis was young. I do know that there's some questions about his mental health or his mental acuity, but I don't know the age of these other people. Maybe some of you in the chat do. In one story, Abrams claims Elvis Fields, and Ned Smith were all in a Muncie hospital visiting a friend on February 13th, 2017. In his interview in 2018, Abrams admitted having his phone with him while in Muncie on February 13th. However, when pressed whether his phone pings would verify that he was in Muncie at the time, Abrams stated that the hospital equipment would likely block his phone's location. Wow. Okay. Abrams coming in quick thinking. During his deposition, Rod Abrams testified that he did not believe he even owned a phone in 2017, which is a different story than he told a few years earlier. I can't see the chat while I'm on the other screen reading, um, so I just wanted to come in and see if anyone had uh, said anything about their ages or whatever. I mean, this Rod Abrams sounds pretty quick. While Abrams and Smith claim that Elvis was with them in Muncie on February 13th, Elvis Fields denies that he ever left Rushville on that day. Yet again, Detective Murphy testified that Elvis Fields' phone records show that the man who constantly used his phone on any given day for some reason did not use it roughly 10:30 a.m. to 7:30 a.m. Okay, he means 7:30 p.m., a period of 9 hours. By Google Maps, it's roughly a 2-hour drive from Delphi to Rushville, giving Elvis plenty of time to leave his phone in Rushville, drive or be driven in a white pickup truck to Delphi to participate in the murders, and then return to Rushville. Also, if the guy was in a hospital visiting a friend, he might not have been using the phone as well. But anyway, these changed and inconsistent stories related to Elvis Fields' alibi, as well as to Elvis's phone activity for February 13th, provide further inferences of connections between Elvis and the murderers and other third-party suspects. Furthermore, while Johnny Messer admits to knowing Elvis Fields, Rod Abrams, and Ned Smith, that is not the story that Elvis Fields and Rod Abrams told police. Both Elvis and Rod denied knowing Johnny Messer. These points were made in documents provided to the court, along with the notes that pointed to the specific pages or timestamps on the items. These inconsistencies and denials provide evidence that the parties can't keep their stories straight on something as basic as whether they know each other. These discrepancies could certainly be viewed by the jury as an attempt by guilty parties to hide their connection in order to deceive law enforcement. These inconsistencies and discrepancies concerning their alibis and whether they know each other are examples of things the jury should hear concerning third-party suspects. These discrepancies, combined with Elvis Field's clear connection to Brad Holder through Facebook and Elvis's incriminating question to Murphy, support Richard Allen's 6th and 14th Amendment right to pursue these third-party suspects. John Messer, a former Rushville resident, is also a suspect in this case who connects the Logansport Delphi crew of Brad Holder and Patrick Westfall to the Rushville crew of Elvis Fields, Rod Abrams, Ned Smith in Rushville. There are pictures on social media of Brad Holder, Patrick Westfall, and Johnny Messer together at an Odinist gathering. That photo was admitted into evidence on August 1st, 2024, and both Kevin Murphy and Todd Click testified as the connection between Brad Holder, Patrick Westfall, and Johnny Messer. Detective Murphy and Todd Click testified that Holder, Westfield, and Messer were all associates with the Vinlander Social Club, hereinafter Vinlanders, a club for Europeans, as explained by Patrick Westfall. Johnny Messer was a probate. I guess that's a title of some sort of stature. With the Vinlanders, uh, Johnny Messer deposition. Detective Murphy and Todd Click testified that the Vinlanders engaged in Asatru-based practices, worshipped gods such as Odin and Thor, and were Odinists. Johnny Messer confirmed that most members of Vinlanders were into Odin, again citing his deposition. Patrick Westfall and Johnny Messer traveled to Minnesota together for a Vinlander event. Same deposition. Johnny Messer's uncle is Billy Messer, quotes the deposition. Elvis Fields previously lived with Johnny Messer's uncle in Rushville, Indiana area. Deposition again. So Johnny Messer's uncle Billy. So who did I was trying to see who did Elvis denied knowing Johnny Messer. Okay. However, one of the most important aspects of the Johnny Messer evidence is Messer's role as a recruiter in the Vinlanders. According to former Rushville Assistant Police Chief Todd Click, Messer denied recruiting members for the Vinlanders. However, Click also testified that he had interviewed multiple men who admitted that Messer had recruited them to join the Vinlanders. Messer's denial of being a recruiter for the Vinlanders, juxtaposed against Click's investigation, revealing that Messer was in fact actually trying to recruit members to the Vinlanders, would indicate that Messer felt he had something to hide. What could that be? The obvious answer would be Messer was the recruiter that hooked Elvis Fields up with Brad Holder. Okay. After all, Messer knew both Holder and Fields, although Fields denied knowing Messer. The fact that Messer's former girlfriend, Taylor Hornaday, told Kevin Murphy that around Valentine's in 2017 that Messer was up there visiting his Vinlander friends. And I think this is the defense pontificating about who those Vinlander friends were, Westfall and Holder. I don't know, maybe she did specify that. And that the red substance she believed was blood was found on the car he drove up there, provides additional connectivity between all these parties and the murders, and that Richard Allen has a constitutional right for the jury to hear those connections. So Messer's former girlfriend is going to say that Messer came up to the Delphi area to visit his friends, and when he drove back around Valentine's Day, does that connect with the time that there was the sacrifice in the woods or the fallout or whatever the case may be? Okay. Keegan Klein and Jerry Anthony Klein. Let me just pop over here and see if there's anything I should be paying attention to. Okay, and we have discussed that it's also true, not really Odinism. It's just sometimes easier for people to say Odinism, but I think everybody does understand that 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 this is not true Norse paganism. This is not true Odinism. These are people who have adopted it and for the purposes of converting it into some sort of white supremacist type platform. All right, so let's move on. Okay, Keegan Kline and Jerry Anthony Kline. Keegan Kline is the son of Jerry Anthony Kline. Was 22 years old in February of 2017, and he and Jerry Anthony Kline resided in Peru, Indiana in February of 2017. Okay. Detective David Vito testified that Keegan Kline was communicating with Liberty German using a fake Snapchat account under the name Anthony Schatz in the days leading up to and on February 13th, 2017. The content of these messages is unknown. He further testified that Keegan Kline admitted to driving to Delphi, Indiana with his father, Jerry Anthony Kline, on February 13th, 2017, and that Keegan Kline waited in the vehicle while Jerry Anthony Kline went to the woods in an area where the Abigail Williams and Liberty German bodies were ultimately found. I know everybody else knows all of these facts, but that one I either forgot or didn't know. Detective David Vito testified that Keegan Kline stated that when Jerry Anthony Kline returned to the vehicle, he had blood on him. Roland Purdy further testified that Keegan Kline admitted that they discarded a knife in the river when they were driving home. All of this evidence creates an inference that Keegan Kline and Jerry Anthony Kline murdered Abigail Williams and Liberty German. Again, I would always tie it back to the language in the statute. You know, they show a connection and the possibility that they could have been involved. I mean, that's all they need to. Doesn't even need to be like an inference that they committed the offense. It just has to show a possibility, a connection, something real. All right, Ron Logan. And then Diz, I don't know if you can hear me, but if there's something important and you click on the post, I'll be able to see that from the screen where I'm reading because I can see like half of the YouTube, the StreamYard screen while I'm over here reading this. So right where the messages kind of pop up. All right, Ron Logan. The bodies of Abigail Williams and Liberty German were located on February 14th, 2017 on the property of Ron Logan. Deposition of Special Agent Robertson. Ron Logan lied to law enforcement about his whereabouts on the 13th. Ron Logan's physical build is consistent with that of the individual captured in the video, and his voice is consistent with that of the voice, all going back to this special agent's report or deposition. And we have seen a release of that report where I'm assuming it's this woman who they took the deposition says that, put together a whole presentation about why the person in the video looked to be Ron Logan. Much like the facts in Allen, the evidence that third parties killed the girls in this manner is exculpatory, unique, and critical to Mr. Allen's defense. The crime scene included many findings that the killers practiced asa true and that it was a ritualistic crime scene. To be exculpatory, evidence must clear or tend to clear. I think there's supposed to be a not. Must clear or tend to clear Mr. Allen of alleged fault or guilt. I mean, okay, I think there's just also a very more expansive definition of exculpatory um, exculpatory evidence that's not as firm as this, but that's what they were quoting. So no, it's not supposed to say not. That's what they meant to say. Okay, I'm gonna say it again. Strike that from the record, please. To be exculpatory, evidence must clear or tend to clear Mr. Allen of alleged fault or guilt. Simply put, if someone else committed the crime, Richard Allen did not. Richard Allen has zero ties to Asatru, Odinism, or the Vinlander Social Club, unlike Brad Holder, Patrick Westfield, or John Messer. Westfall. The above evidence is exculpatory, unique, and critical to Mr. Allen's defense. The above evidence that the state wants to hide from the finder of fact is admissible for two reasons. One, it demonstrates the investigation and failures with the investigation. And two, the fact that a distinct possibility, if not high probability, that people other than Richard Allen killed Abigail Williams and Liberty German. Uh, Two, I mean, I would have definitely added a three that it describes the crime scene and presents a motive of the offense that is exculpatory in nature as well. Just for his lack of any connection with something that would even appear ritualistic. 3, although I think this is 4 because we had a 3, but whatever. Richard Allen has a right to introduce evidence of motive, as it is always relevant. Evidence of motive is always relevant in a criminal prosecution. Okay, so that gets right to my what I was saying was a 3. In the sentence above. In the context of third-party motive evidence, an accused must tend to show some connection between the third party and the crime before the evidence is admissible, citing Tibbs, citing Pelley v. State, and that's that 2009 Indiana case. In this case, the prosecution has no proof of any connection of Mr. Allen to Abigail Williams or Liberty German, nor have they identified any motive as to why Mr. Allen would kill them. There's absolutely no evidence as to Mr. Allen's motive to commit the crime. What does exist, however, is motive on the part of Patrick Westfall, Brad Holder, and others to kill Abigail Williams and Liberty German. Brad Holder knew Abigail Williams as his son was dating her at the time of the murders and had supervised them on at least 2 dates. Patrick Westfall participated in animal sacrifices. True sacrifices are carried out in order to provide the offender with power through runes, blood, and binding runes, all of which are present at the location where the bodies are found. This provides motive for Brad Holder, Patrick Westfall to murder Abigail Williams and Liberty German as part of an Asatru Odinistic sacrifice. It still, I don't think he needed to say it was part of a sacrifice, but does show that the person who committed these offenses had knowledge of and ties to Asatru and Odinist. And inherent from that flows that there were these, there's this evidence that speaks to an Asatru ritual, even if the sacrifice itself wasn't. So, wherefore, for the reasons identified above, Richard Allen by counsel respectfully requests the courts to deny the prosecution's motion in limine as it relates to Odinism, cult, or ritualistic killings. Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Anthony Klein, or Ron Logan for all of the just and proper, and for all other just and proper relief in the premises. And then there's just an okay. All right, guys. So there you have it. So let's go here real quick. Brittany Ballard says, we do not sacrifice anything. We give offerings of food and gifts, not humans or animals. Disgusting human beings did this to these beautiful girls. Again, I don't think that we have to think back to Lori Vallow and where they were corrupting an actual religion and putting their own tilt on it. I don't think um anybody was uh thinks that that's actually Odinism or Norse paganism. So hopefully no one's making Brittany feel that way. Jackie Johnson says Ron Logan was not mentioned in any detail. Uh, well, we read the Ron Logan. There was an entire Ron Logan section here, and I think he was first. Maybe not. Or was he the one we just read? Yeah, Ron Logan. So yeah, it was pretty short. I think they think everyone pretty much knows about that. The bodies were found on his property. He lied to law enforcement about his whereabouts. His physical build's consistent. His voice is consistent. And he's got these ties to Asatru and Odinism. Um, so I think that was right. I mean, he doesn't. I think there's less to say when the things are like very clear cut, found on his property, you know, his physical build's consistent. He's got ties to, um, wait, does he have ties to everybody else? Or, oh, right. So yeah, um, there wasn't too much there. So Ron doesn't have any other, I think what happens in my mind, I confuse Logan Holder with Ron Logan. Um, So have we heard about any more connection with Ron Logan and having a connection with Odinism or Asatru? Yeah, that's what I'm saying. I'm not sure. And I can't keep everybody straight at one time. So we'll have to, if anyone else in the chat knows, I would assume there's not much, or they would have put some more. They would have put it in here. They're not shy about repeating things. Um, So, does anyone know if Logan had any ties to I'm you know, I'm gonna say, and without Bob here, because he's obviously gonna know a lot more than me, that no, there were no ties, because I could guarantee you they would have put it in here, like, they're again, they're not shy about repeating themselves. So, I would agree uh, you know, with Jackie Johnson here. Ron Logan, I mean, there wasn't much detail. It sounds like the only thing that they think is that he's found near his property and he looks like these people. So, Ron, in that scenario, because you've got these different groups, right? You've got Ron Logan, who I think Ron Logan would be, well, you just picked Richard Allen out because he was like in the area and you don't have any real motive and you don't have any, so Ron Logan's comparable to that scenario where you've just got a guy who decided he wanted to kidnap and hurt these two girls. Then you've got the whole Asa True circle. Um, whether they're just perverts who also are um Vinlanders. So that's why there's some aspects of that in there. or whether it was an actual ritual, which it seems unlikely. It seems more like it was just there was another motive behind it, and you're seeing this uh, ritualistic stuff because these are the people who committed the crime are people who are Vinlanders. So it's kind of just like a happenstance that's it. Or, who knows? And then you've got the other third party suspect, what was, in the area, went into the woods and was uh messaging Liberty German using a fake Snapchat account. And I know that guy was, investigated, but I mean, that's definitely something. Is that just happens to be dumping a knife in the woods at the same time from Peru to Delphi? I don't know. I don't know. Um, Jackie also asks, were those details in the memo? That would mean they want to blame him. How would Gull know they want to blame him unless it's in this memo? No, no, no. So the only details in the memo for Ron Logan were that it found on his property and he looked like Ron and he sounded like Ron. So I'm agreeing that there were no details about Ron Logan having any connection to Odinism or anything. So if he would have, I can assure you it would have been in this. If there was anything found, I see people saying like, well, I heard they searched for books. If they would have found a book that even hinted at anything, the defense would have put it in there. They would have done that to tie it. So when Jackie's asking, were those details in this memo? I don't know. Uh, I just kind of spewed out a couple different details, but all of the ones that I was spewing, I had went back in and read. But for Ron Logan, no, there's no details connecting him to um, Odinism. It was just that I'm just going to pull it back up so you can see kind of what happened. It was just that it's that sentence right after Ron, which is really just like their ending sentence, but uh oh, so see Ron Logan, it's basically this is it. But then the next sentence without kind of saying conclusion or something is much like the facts and evidence that third parties killed the girls in this manner. Blah 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 blah. The crime scene included findings that the killers participated in Asa True. Richard Allen has no ties, so but no, they're not really connecting these things to Ron Allen. Ron Logan is just they're located by his property, tied to lied to law enforcement, and that he looks like the person captured on the video and sounds like the person captured on the video. And again, so I'm saying Ron Logan is, an alternate suspect under the same type of theory that the police have with Richard Allen. They don't know why. The guy just decided to, you know, kidnap these girls and kill them. Um, okay, and then you just got other people all saying that we haven't heard of any ties to Ron Logan with Odinism. Yeah, I feel confident in saying there is not. Um, or the defense clearly they are putting in no matter like any kind of inference you can draw from anything. If they could have made some sort of argument that connected him to um to Odinism or Asatru, they would have. All right, guys. So I guess take a break and hopefully you will. But wait, nobody leave anywhere. I have something super important to say. I almost forgot. It's really, really important. I'm so glad I remembered this. Let's see. Hold on. And don't be mad because I'm kind of lying. There are 492 people here. We have a lot of thumbs up, likes, 267. Please, 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 give us a thumbs up. And I don't know if I put this back up or if Dizzy put this back up with Jackie Johnson, or if I left it up. Oh, sorry, but I think that I answered it. Is Kitty also are you Viking? Or I don't know what the heritage is, Norse pagan. Look, I don't think anyone is gonna associate it with anything legitimate or, you know, or real, you know. Um, so I'm sure that that everybody knows or should know this is not uh even if there's some association with the Vinlanders, that is not a true representation, obviously, of Norse paganism or Odinism. Um, so hopefully that's not an issue. Oh, I ended up clicking. That was really a really old comment from Kitty, but let me check on you guys here. Let me see what you guys did with these thumbs up. If I can even see. All right. All right. It's going up. It's going up. All right, guys. So I'll let you guys go. We're going to be back, Bob and I, in about a half hour. I'm sorry. I was just looking more at you guys' comments too. Thank you. I love you guys as well. Sorry, I'm not good at just talking as Bob is, but hopefully I've answered your questions, and see you soon. See you in a little bit. Dizzy, you know how to do that outro thing? All right. See you soon, Diz. Thanks. Oh, I'm still on? Darn it.